It's not a conspiracy theory. It's a business practice. Larry Silverstein made $7 billion off the attacks on 9/11. Grow Life. This was probably my favorite one right here. You can tell by all the holes in it. Somebody was asking where I got these t-shirts from, or the one that's Be the Change Makes Sense. And I printed them. I bought a printer when I was leaving my old life to try and have some legitimate income. And like a month after that, every place online was like, hey, we'll print stuff up for you real cheap. All you gotta do is send us an image file. So that didn't work out too well. But all of these shirts I printed myself, so I feel very fond of them. Thank you for enjoying them as well. Garrett, I see that you're sticking around and you're watching. I feel you about the cops, man. Cops are breaking the law all over the place, and it should be exposed. The only problem is it doesn't really matter exposing it if you don't go get a court of law to hold them accountable in. This is why I kind of advocate, like, if we just correct the judiciary in this country, if we just make sure the judicial officers are following the law, then they should make sure that the cops are following the law and the politicians are following the law and the lawyers are following the law. But when society allows judicial officers to be above the law and the law doesn't apply to them, then typically they allow all their friends to be above the law and make sure that the law doesn't apply to their friends, to their gang, to their set. And that's why I think it's really, really important to watch courts. And if you wish to watch courts, we're going to be at the Henderson County Courthouse October 11th, 2023, 9 a.m. Joni Ramo. So I think it'll be pretty interesting if anybody's interested. And with all of that being said, I've kind of given up on having any type of hope for the future, because Oracle filed this lawsuit against Tyler Ray and Peter Knight basically to ask for a court of law. And they won't give her a court of law. And she was just asking for a jury to go after her mom, Josephine, who ran away with all of the family trust and all of the family trust assets. And the government doesn't really have any business being involved in this at all. And they won't do that. And that's scary. And they won't say why they didn't do it. They're just not answering at all, because I guess they think they don't have to. I don't know. Anyways, because of that, all of the stuff that I know is basically useless, so I'm just going to tell everybody what the ideas of it are, what the secrets are. The things that I've seen work miracles in the past, I'm just going to tell everybody, and they can do with it what they wish. I'm done having any sort of hope, because nobody cares. Anyways, with that being said, Oracle, at the very, very top of her paperwork, it says court of law. What is this court of law? Has anybody ever seen a court of law in our lifetime? Why is it so mysterious? And when we go and we look at the United States Constitution, here's what it has to say about the judicial powers, the courts, the judicial courts, and what type of power Congress has over them. The United States Constitution, Article 1, Section 8, Clause 9, the Congress shall have power to constitute tribunals inferior to the Supreme Court. Congress only has the power to make courts that are inferior to the Supreme Court. What is the Supreme Court? What is the Supreme Court? Because that's a really, really good question. And again, there's not like one place you can just go look up the dictionary of different courts. What is the Supreme Court? And everybody believes that it's SCOTUS, the Supreme Court of the United States, or the Supreme Court of South Carolina, Supreme Court of Illinois. But that's not what it is. See, Supreme in that sentence is lowercase. They're talking about a description of a court. And so let's go look at some other constitutions that were kind of written around this time, see if we can get a clue about the Supreme Court thing. Let's check out South Carolina's Constitution first. Constitution of South Carolina, March 26, 1776. 17. That the jurisdiction of the Court of Admiralty be confined to maritime causes. 18. That all suits and process pending in any court of law or equity, if either party shall be so inclined, be proceeded in and continued to a final ending without being obliged to commence de novo. And the judges of the courts of law shall cause jury lists to be made and juries to be summoned, as near as may be, according to the directions of the acts of the General Assembly in such cases provided. I absolutely love South Carolina's Constitution. We say, hey, the courts of admiralty, their jurisdiction just is over there in maritime, that's it. You don't take it any farther. And everything else, there's a court of law. And whenever somebody's in a court of law and they're a party, at any time they wish, they can tell the judge to just pull in a jury, for real judge, and have it settled, right? Because that's basically what the judicial officer is there for, is to witness the verdict of the jury. But I know this was real simple for South Carolinians to read back in 1776 because everybody knew what a court of law was. But if we didn't know what a court of law was, where would we go find that information? Because a lot of people back then, they didn't just write it down. Everybody knew it was common knowledge. That's why they call it common law. But we're in luck. Georgia, they wrote down something. Constitution of Georgia, February 5, 1777. Article 40, all causes of what nature soever shall be tried in the Supreme Court, except as hereafter mentioned, which court shall consist of the Chief Justice and 3 or more of the justices residing in the county. In case of the absence of the Chief Justice, the senior justice on the bench shall act as Chief Justice, with the clerk of the county, attorney for the state, sheriff, coroner, constable, and the jurors. And in case of absence of any of the aforementioned officers, the justices to appoint others in their room pro tempore. And if any plaintiff or defendant in civil causes shall be dissatisfied with the determination of the jury, then, and in that case, they shall be at liberty within 3 days to enter an appeal from that verdict, and demand a new trial by a special jury to be nominated as follows. Each party, plaintiff and defendant, shall choose 6. 6 more names shall be taken indifferently out of a box provided for that purpose, the whole 18 to be summoned, and their names to be put together into a box, and the first 12 that are drawn out, being present, shall be the special jury to try the cause, and from which there shall be no appeal. Article 41. The jury shall be the judges of law as well as of fact, and shall not be allowed to bring in a special verdict. For any cause whatsoever, be it civil or criminal, we're going to have 3 judges, 3 judicial officers. We're going to get the county sheriff, the coroner, the attorney for the state. We're going to get everybody to come and witness this. And on top of all those government officers who are going to witness this, we're going to get a jury too, because they got to come back with the judgment, because the jury decides the facts and the law. And if you're going to appeal, you only have one appeal, only in a civil trial, showing you that the private person back then could take you to court over criminal issues. It was your job to prosecute criminal wrongs that happened to you. How did you do this? Because everybody knew and understood law. It was really, really simple. And what do they call that court in Georgia? They call it the Supreme Court. Funny enough, the Supreme Court, that is the trial court. That is the trial court. And so this is what I argue is the Supreme Court, and that is a court of law. And not all states wrote it like that. in their constitution. But if you read a lot of legal history, I think you might come to the same conclusion. Anyways, a court of law is someplace that you held people accountable who did wrong to you. And this is why we don't have control of any government officers anymore, is because a man or a woman cannot go into a court and verify a wrong that a government officer has done to them and get any kind of remedy for it. Even if it's not to get remedy from the judicial officer or the clerk, it's just to get remedy that they quit breaking the law against you so you can sue your mom. Because we can't even get that. There is not enough law left for the state to say that you have the right to go after a private individual for a private wrong. But what happened back in the day when you could do these things? Well, the Maryland Constitution could have a clue for us. Constitution of Maryland, November 11, 1776. 39. That if any senator, delegate to Congress or Assembly or member of the Council shall hold or execute any office of profit or receive directly or indirectly at any time the profits or any part of the profits of any office exercised by any other person during his acting as senator, delegate to Congress or Assembly or member of the Council, his seat on conviction in a court of law by the oath of 2 credible witnesses shall be void, and he shall suffer the punishment of willful and corrupt perjury, or be banished this state forever, or disqualified forever from holding any office or place of trust or profit, as the court may judge. 40. That the chancellor, all judges, the attorney general, clerks of the general court, the clerks of the county court, the registers of the land offices, and the registers of wills shall hold their commissions during good behavior, removable only for misbehavior on conviction in a court of law. Disqualified, banished forever from holding any office of trust or profit. You remember when I kind of started this whole thing with Oracle? It's like, hey, we're going to talk about trust law because this trust was violated against Baba. And there's a trust that many people probably believe is being violated right now. It's called the Constitution of the United States, or your state constitution. See, these people who are in positions of power, positions of trust, positions of profit with the state, you used to be able to hold them accountable. And how did you do that? In a court of law. Anybody convicted in a court of law. What's that? That's when a man or a woman goes down to the local courthouse and verifies facts upon a court record, and they issue a true and lawful judgment in law. That's what that is. That is basically what Oracle's been trying to do this whole time. That is why they have stopped her. They won't let her go down there and verify the facts that she put on a piece of paper. And they won't allow her to get any relief. All Oracle is asking for in this action is her right to prosecute Josephine before a jury. That's it. That is all that she's asking for. And she's saying the reason I'm asking for this is because I cannot get a fair trial in Hendersonville. I have seen them violate the law way too many times. Let me just go through it point by point by point for you. This one will be a long one. And one thing that I just got to kind of point out, since we're on these old constitutions, is the New York Constitution, where it talks about licensing attorneys. The Constitution of New York, April 20, 1777. 27. And be it further ordained that all attorneys, solicitors, and counselors at law hereafter to be appointed be appointed by the court and licensed by the first judge of the court in which they shall respectively plead or practice, and be regulated by the rules and orders of the said courts. Ha ha ha, see, in court of law, in law and equity, but the attorney, the counselor, they're only counselors and attorneys at law and in equity. They can't be in law. That's probably pretty important. They probably understand what that means. And that's why this is in a court of law at the Court of Appeals. In a court of law at the Court of Appeals. And who are the parties here? Let's just check this out real quick. It has Joni Ramo, Oracle. Oracle is the injured party. And Oracle's going against J. Tyler Ray and Peter Knight, clerk and judge of Superior Courts, cause injury. See, this is how simple law is. It doesn't have any real confusing words like plaintiff and defendant, right? It's like, hey, I got injured, I got harmed, and you harmed me. What do you got to say about it? I think everybody can basically understand that one. That's why it's common. That's why this is known as common law. And what is this about? We don't know, but it's a declaration for relief from extraordinary wrongs. Extraordinary wrongs. See, her last action, her last declaration was for extraordinary writs to just correct one or two of those extraordinary wrongs. But they wouldn't allow her to open up a court. So now she's talking about a lot of extraordinary wrongs. And the court, through their action, through not speaking, is basically telling you that you have no rights, and it's part of the government's job to beat you up, throw you in jail so that they can take away your property and distribute it to every wrongdoer they feel like distributing it to. Because there is no law, there is no justice, there is no way for you to find law or justice. Get ready, because hell will be here quickly. Very, very quickly. And the only thing we have to do to stop it is get a court of law. And this is really, really scary, because when Oracle was down at the Court of Appeals filing that, the guy who was really, really helpful, because we walk in there and the clerk looks at our paperwork. I'm guessing she was like, these sovereign citizens. But she doesn't know. So she gets an attorney over there. I'm just guessing the guy's an attorney. He had a little badge. She called him over. He had the authority to okay the paperwork. That's kind of scary in and of itself. But he's looking at it and he doesn't know what it is. He does not know what an action in law from a man or a woman making verified accusations about government officers, he doesn't even know what that is. And I was like, well, it's obviously kind of a declaration for extraordinary wrongs, so I'm guessing it's asking for extraordinary writs. Yeah, but which one? Read the whole thing. There will be several. But more or less, Oracle's just asking for a writ of certiorari. She's just asking that you produce a court of law instead of this kangaroo thing you got going on down there. But it's a long action, and because it's so long, it's going to be presented after this in kind of two different ways. We're going to have the facts, and then we're going to have the actual substance of the law. But it's just going to be read. You're going to see the paperwork. But we got to get through some of these first principles first, right? You have to understand what a court of law is. You have to understand that it's not the government's administrative courts. You have to understand that the whole reason this has gotten this far is because we haven't had courts of law, and now the government is telling you there is no such thing. So get ready for hell to come up here. Get ready for hell. Anyways, let's just look at Article 3 explaining the judiciary in the Constitution of the United States.
Judicial Department, Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior.
The judicial power of the United States is vested in one Supreme Court, and then other inferior courts that Congress might decide to create every now and then. The way I read this and interpret it is that the Supreme Court and the inferior court are the same courts. They're one and the same, but the Supreme Court is supposed to be supreme. That's that court of law. They can create their administrative courts. They can administrate anybody who wishes to be administrated. But when a man or a woman walks in there and says, here's what the law is, stop causing some type of unpleasantry in my life, because only the judicial powers of the United States can cause real lasting change to your property rights. The legislature can't do it, the executive can't do it without the judiciary signing off on it. That's why everybody should be focusing on the judicial courts. That's why they're a much bigger concern if you think it's going to turn 2030 and you'll own nothing and be happy, because the only way to get that done is by taking away law. And when do they have this judicial power? When can they be sitting? During times of good behavior. During times of good behavior. When people come in and verify wrongs or misdeeds that you have done in a public courthouse, that's supposed to be heard so that we can find out if there has been misbehavior or not. If you have been behaving well, because if you haven't, we should get you out of office. Look at Greg Newman. It took 6 years to get him out of office. One could arguably say 6 years, he shouldn't have been acting as a district attorney, basically his whole career. These are things we got to think about. Well, let's see what happens with this interpretation.
One Supreme Court. The convention left up to Congress decision on the size and composition of the Supreme Court, the time and place for sitting, its internal organization, save for the reference to the Chief Justice and the impeachment provision and other matters. These details Congress filled up in the Judiciary Act of 1789, one of the seminal statutes of the United States.
Did you see that? Did you see that switcheroo? See, up there in the Constitution, Supreme Court is with the lowercase s. Down here in the Judiciary Act, talking about from the Judiciary Act, it has a capitalized S. And that's really, really important, because up in the Constitution, it's a descriptive word, which means the highest form of law, the supreme. There's nothing greater. And then down there in the Judiciary Act, it's just a name of a place, like a Supreme Court building, right? It's just a name. That's the only reason it's capitalized. When it's capitalized like that, for sure, it cannot be an adjective, because an adjective wouldn't be capitalized. Not in the English language, not speaking properly or writing properly. I don't always speak properly, but when I write, I try to make sure that I communicate very, very clearly. Very clearly. That's what I believe they were doing in the Constitution. And this what leads me to the belief, because Congress created that Supreme Court with the capital S in the 1789 Judiciary Act, and in Article 1, Section 8, Clause 9, it clearly says that Congress can't constitute a Supreme Court, doesn't have any jurisdiction over a Supreme Court, over the Supreme Court of Law. That's the way I would read it, but Let's look into some of these inferior courts. Well, let's see what they're talking about with inferior courts.
Inferior courts. Congress also acted in the Judiciary Act of 1789 to create inferior courts. 13 district courts were constituted to have 4 sessions annually, and 3 circuit courts were established to consist jointly of 2 Supreme Court justices each, and 1 of the district judges of such district, which were to meet twice annually in the various districts comprising the circuit.
The inferior courts are the other courts created by Congress that most people would think of as a true court of law, like the district courts and the circuit courts. Those are inferior courts. But again, from kind of my interpretation, and if you think about it, it really kind of already works this way, where the Supreme Court sets precedent that lies underneath the lower courts and kind of guides them on how they administrate their own decisions. That's the entire idea of case law and precedent. But with my understanding, real law underlies that. That's what trumps administrative case law precedent. Because you can't have a case law, you can't have an administrative rule that actually causes harm to people. That would be crazy. That would not make any sense because the government's not real. Corporations are not real. We are. We are. But these courts are the inferior courts that they're talking about. And the only reason they have judicial power, in my interpretation and my understanding, is because they're supported by that Supreme Court underneath. The court of law. The court that is too supreme to be inferior. The one that Congress doesn't have any jurisdiction over. Let's see other courts that they do.
Courts of specialized jurisdiction. By virtue of its power to ordain and establish courts, Congress has occasionally created courts under Article 3 to exercise a specialized jurisdiction. These tribunals are like other Article 3 courts in that they exercise the judicial power of the United States, and only that power that their judges must be appointed by the President and the Senate. Legislative courts. Legislative courts, so called because they are created by Congress in pursuance of its general legislative powers, have comprised a significant part of the federal judiciary. The distinction between constitutional courts and legislative courts was first made in Americans Inc. Co. v. Cancer.
There's a difference between a legislatively created court and a constitutional court. Maybe the difference is the legislatively created court doesn't have the power of the judiciary and law because it doesn't have the Supreme Court underneath it. It's not supported by the Supreme Court. That's not the supreme law that they listen to in that court. They listen to the law of the legislatures at the Capitol, going to that temple of Jupiter in Rome. Going to that temple, representing the gods here down on earth. And there's a lot of administrative specialized courts. And again, they make up a substantial part of the judiciary, right? And let's think about some of these administrative specialized courts, because I bet we've all heard of a couple of them, like traffic court, or family court, or juvenile court, tax court, bankruptcy court, probate, magistrate, district, superior, supreme. In New York, they call their trial court the Supreme Court. That is what the legislature has decided to name it. And so it really kind of comes down to this idea of what is the supreme law? Who writes the supreme law? Does it actually give justice? Does it serve the people? Does it serve the best interest? Or is it self-serving? This is the society you get right here when you can't hold public servants accountable. And Oracle, as you're going to see throughout her action, throughout her suit, she's not even asking to hold Peter Knight or Tyler Ray. She's not asking to hold anybody accountable. All she is asking for, all Oracle is asking for, is for her right to go and prosecute her mom on a private claim arising from private family business. The government shouldn't have any involvement, any right to interfere, any duty to interfere, any ability to interfere. If somebody can come and steal every single thing you possess, run away with it, have the money to pay off the legal society, have the money to keep it from you, and you don't have any recourse at all, you can't go down there and say the truth, put the truth on the facts, on the record of the court. If you can't do that, you're a slave, because you can't own property. And if you can't own property, you are property. You are property. It's just that simple. And if you can't go down to the courthouse and verify facts for the record to secure your property in law, then you don't have property. It's not yours. You cannot choose how to distribute it, where it goes, what's going to happen. And if you don't believe that that's going to happen, if you don't believe that can happen, it's happening now. And the courts, again, are not even appearing to uphold Oracle's right to have a court of law against her mom for a private reason. So there are no more rights. These are your most sacred, most secure, fundamental property rights that has made America this shining beacon of the world for having due process of law. And even though we can argue about the meaning of the Supreme Court and whether that actually means like a Supreme Court of law is actually underlying the judiciary, what we can't argue about is the fact that in the constitutions, and all the constitutions that I've seen, it says that you have the right to due process of law. Not some administration, not due process to be administrated the way that the legislature decides for you, or the way that the executive feels like administrating you, or the way that your public officials that are down at your local courthouse decide to administrate you without any provocation or law behind it. No, it says that you have the right to due process of law before any order can be entered into a judgment scroll to take away property from you. But that right is only as good as the people who uphold it down at the courthouse. And the ones down there right now, they ain't doing a real good job. And the fourth branch of government, the media, they're telling us there's no story in here. I guess it just comes down to you. But I've given up. That's why I'm going to teach everybody a history lesson. Give you all the secrets. Here's how it all works. How it all did work. Let go. Have fun. God be with you. Godspeed. But I don't see it ever turning around. I don't see law ever coming back, and I hope to be surprised. I hope to be surprised, but I'm not going to be surprised at all when this world looks like hell for some people in about a year. We are just conspiracy, and we just wish to conspire to bring heaven down to earth. We can do this if everybody just knows, understands, follows law, and makes sure that it's upheld down there at the courthouse. Otherwise, we might bring another place. One world, love, and peace.